As of 2005, someone would have to be a danger to themselves, others, or property in order to be involuntarily committed.
Your Honour, I'd like to show Tyler Jordan the DSM-4 as of 1994. Are you familiar with the V code 6289 in the DSM-4? Given that Anna wanted to be treated under this V code and she was refused, would you consider this to be a violation of her rights?
It depends on whether or not she was declaring that she wanted to be treated under the code and the enforcement officers or the medical care professionals actually knew what code she was referring to, and maybe based on her behavior otherwise, whether or not they would have honored that.
So she would have to have declared that at the time of the detainment for them to then consider using this at the hospital to inform the doctors ahead of time.
And also the competency of the medical professionals would have been that issue as well.
Is it a matter of awareness and enforcement?
Yes, application of the law usually comes down to matters of awareness and enforcement. You're critically relying on your law enforcement or legal personnel as well as your medical personnel to know the laws and implement what is correct and not violate people's due process rights or others, which are protected in the state of New Jersey. Anna and Bill Moore, and cases like hers, individuals have the right to make an advance medical directive in order to direct how their treatment is to be undertaken in cases where they're not able to openly declare and state what treatment they want to receive. So even if she's not capable, she's not able to speak, she's not able to communicate properly, she can in advance make a declaration about how her treatment should be handled.
So some examples of the Universal Declaration of Human Rights are: everyone has the right to life, liberty and security of person. No one shall be subjected to torture or to cruel, inhuman or degrading treatment or punishment. And everyone has the right to freedom of opinion and expression. Had she specified what degrading treatment meant to her, if she had wrote it in the advance directive ahead of time, would that have meant that if the medical professionals continued to give her the defined degrading treatment, that they would have been in violation of her rights?
It very well could. If they were aware of her advance directive and she clearly defined what was defined as degrading treatment that she did not want to receive in her best interest when she was in a cognitive and clear state of mind, then that could have very well violated her rights.
Mm-hmm. And what repercussions would there have been for the treating physician had they continued to go against her advance directive?
Civil violations as well as license violations.